Welcome everyone to the afternoon session of our first day of the November call. We have two cases to hear this afternoon. The first one is Donna Livings versus Sage Investment Group. Mr. Barata and Mr. Conn, this is a mini oral argument on the application, which means you each have 15 minutes. And Mr. Conn, you may reserve, but you'll keep track of that yourself. And you may proceed. You're going to have to unmute, Mr. Conn.
False start.
No problem.
May it please the court, Eric Conn appearing on behalf of the appellant and defendant, Sage's Investment Group, LLC. I'll do my best to reserve 2 minutes for rebuttal time if possible. Employment is not a relevant consideration when determining whether an open and obvious condition is effectively unavoidable. I'd like to make a couple of key points very briefly, and then I'll waive the free fire zone. First, Michigan precedent correctly establishes the narrow and objective standard employed, and this court should take the opportunity to reaffirm that case law and clarify what it means to be effectively unavoidable. Second, objective standards have practical workability, and they promote, therefore, fairness, reliability, and predictability in the law. Third, when we determine status in premises liability cases, we already consider employment, and therefore doing it again in the duty analysis with open and obvious conditions and effectively unavoidable would be superfluous. And finally, addressing this court's second question, even taking the facts in the light most favorable to the plaintiff, her deposition admissions confirmed she had options available to her to avoid the open and obvious condition here and chose not to. Therefore, summary disposition should have been granted. That said, I'll now waive the free fire argument and address any questions there may be.
Thank you. Justice Clement.
No questions at this time. Thank you.
Justice Kavanaugh.
I don't have any at this time either.
Justice Markman.
No questions, thank you.
Justice Zara.
No questions right now.
Justice Viviano.
I have no questions at the moment either.
Justice Bernstein.
No questions.
Okay, I'll bite counsel. The language from Hoffner that I believe you rely on is that the plaintiff's existing relationship to a business shouldn't alter the duty of care. Is that primarily the language that you believe should govern here?
From the Hoffner decision, yes. I'm sorry.
No, go ahead.
The language in Hoffner specifically states a couple of things. The first is, and addresses the reason why I don't believe we should be considering employment twice, both at the status level and at the special aspects level. And that being, doing so creates a heightened duty of care, as the Hoffner decision reveals in its majority opinion. Specifically, it does that by creating a fourth, if you will, status upon land, and that exception would swallow the rule when it comes to open and obvious conditions, because it would allow essentially for a subjective test, first of all. Second of all, this court has never created, as far as I'm aware, in premises liability, a heightened duty of care such that the plaintiff is seeking here to determine whether special circumstances can avoid an open and obvious condition. Instead, the only time that I'm aware that a heightened duty of care has been accomplished is through MCL 554.135, which allows if a common area isn't suitable for its intended use, then the statutory duty there obviates the application of the open and obvious doctrine. Can you
walk me through a little bit better why you say it's a heightened duty of care? I'm just trying to understand the special aspects framework and whether a hazard is unavoidable. And so where would the heightened duty of care come in for an employee who had to get into work?
Certainly. The analysis is the same as it is in Hoffner, which essentially is When we look at trespasser, licensee, and invitee, we're looking at the purpose for why the person is on the land. When
Right.
we look at an invitee, we're looking to see whether or not there's a pecuniary interest, an economic interest that's mutual, that both parties would share, therefore creating the highest duty that our common law provides. When you look at the purpose for why the person is on the land, in determining, okay, well, this person has, for example, in Hoffner, a contractual right to be there, or in this case, an employment right to be there, then what you are doing is you are essentially creating that additional duty, because you're looking not only at the reason that why they are there, but you're also looking to what rights and duties they have to use the premises itself. That in and of itself does two things. One, it creates that heightened duty, as I've said, but two, it also changes the dynamic of the objective standard that's been employed. And it moves it from the objective to the subjective, and this is why. When we look at open and obvious conditions and whether they contain special aspects, the common law has always said that it's an objective standard, and you look at the condition itself to determine whether it has special aspects. By looking at the plaintiff or the claimant, you're turning that on its head, and you're actually looking to the reason why the person is there and what is important to them to get around an open and obvious condition or to encounter an open and obvious condition. That's never before been said in the common law. The common law instead has relied upon the objective nature of the condition itself. Lugo has said that, Riddle has said that, Bertrand has said that, and
So
the
it's-
cases that they, go ahead, I'm
Just
sorry.
to interrupt you briefly. So it sounds like you just think it is the proposition that flows naturally from Hoffner. I mean, Hoffner's language was neither possessing a right to use services nor an invitee's subjective need or desire to use those services heightens a landowner's duties. But I guess I would wonder, my question is an employee there to use services or to deliver services? And is that not relevant to whether or not the hazard is avoidable?
It is not relevant, in my opinion, Your Honor. And the reason why is because that question goes to the status issue. And once you get past the status issue to determine which level of duty is owed, then you look at the objective nature of the condition itself. So it doesn't matter if somebody is there to give or receive services when you're talking about the objective standard that's employed pursuant to Lugo, Riddle, Bertrand, and the cases that came before them.
Thank you.
Thank you. And this goes to the crux of the argument that I wanted to make here today, which essentially is that this case law, this body of case law was correctly decided. And it started, of course, at common law. And as Bertrand and Riddle before Lugo identified, there's an objective standard that we rely upon in order to make these types of determinations. Lugo then did what the appellant is requesting this court to do today, which is to serve as a building block, not only to reaffirm the common law in this area, but also to clarify the objective standard that is to be employed. Prior to this case, what has been done and implemented by the court is to use that objective standard that I've been referring to. And essentially what that boils down to when it comes to effectively unavoidable circumstances is to look and see whether a plaintiff had options. And if a plaintiff had options to avoid an otherwise open and obvious condition, liability would not extend and the landowner would not be responsible for the damages alleged. That is wholly consistent with this court's determination and adherence to the fact that a landowner is not the insurer of an invitee. And this court has the opportunity here to reaffirm that longstanding tradition, that longstanding adherence that this court has implemented. Second, I want to talk about the objective standard. And objective standards, as this court is well aware, have practical workability. And that practical workability that the objective standards have permit a reliable, fair, and predictable outcome. And when we talk about fair, we don't talk about the emotional conditions in a particular case, but we balance those. We don't look at one party or just another party, and we balance those. And what a subjective test actually does is it looks at the point of view of one person. And that's the argument that's being made here. You look at the plaintiff in this particular case to see whether she believed it was necessary to go to work on this particular day. And when you set it up with just one side being considered, that marks the unfairness that has been refused to be applied at common law in these particular cases. And that is no better seen than in the Lyman decision, which is a Court of Appeals published opinion, and the problems that have arisen from that opinion in the last several years. In Lyman, as the court is aware, the plaintiff was a home health care aide, and the court in the Court of Appeals looked at the importance of that person's job in making a determination that the condition she was faced with was effectively unavoidable. And I'm quoting here from Lyman now. Plaintiff in this case was compelled to enter the premises because she was a home health care aide who could not abandon her patient. An essential home health care aide did not have the option of not appearing for work. So what the court did in Lyman is it considered the importance of the plaintiff's job above all else. And it did exactly what I was just referring to, Chief Justice McCormack. It looked at one person instead of anchoring itself in a community standard, which is what the reasonable person standard does and always has done. And it's the reason why in premises liability law, we have the practical workability that we do. We have the ability to come to fair, predictable, reliable outcomes. If we rely upon the subjective standard that is being requested here, we take it from that mooring and we look at the whims of one particular person or one set of people without looking at the community standard, which has been determined to be important and dispositive in this area of law. That creates a real problem with adjudication, not only at this level, but as we've already seen in the Court of Appeals, based upon the cases, in fact, the recent case that was just accepted on another oral argument on application by this court recently, but also in the trial courts as well. So we should refrain from doing that. Instead, we should look to the workable, and in my opinion, the only workable test, which is the objective test. I see I'm running out of time, but I want to.
Chief Justice, can I go out of order and ask a question or two to follow up? Is that?
Yes, sorry, I was muted. Go ahead.
The question I have, counsel, your position is we should reject the section 343A of the restatement. Is that right?
343A1 has been adopted. I think there was probably a typo. I saw that mentioned in the amicus brief. 343.1 has been adopted. My concern is actually with the comments of the restatement.
Well, before you get to the comments, the text of the restatement talks about the possessor of land is not liable to his invitees for physical harm caused to them by any activity or condition on the land whose danger is known or obvious to them, unless the possessor should anticipate the harm despite such knowledge or obviousness. And so the reason I went out of order in my questioning is you keep talking about it from the perspective of the plaintiff and how difficult that would be, but that's not at all what the restatement focuses on. It focuses on the possessor of the land and whether the possessor should anticipate that somebody's going to confront the danger despite its known or obvious aspect that it has. And this, of course, then lends itself to look into the employment setting in terms of whether people are more likely to confront a hazard to get to work or not. And so I guess the first question is, why do you think, or aren't you misreading the restatement when you keep telling us we should look at it subjectively from what an individual might do as opposed to what the landowner should anticipate?
No, to be clear, my argument is it should be looked at objectively. And I believe the Bertrand and Riddle decisions actually looked at 343A and made that same determination. And that was developed even further and clarified by Lugo. So my opinion is the current law of the land in Lugo, as it's been decided there and throughout the last 19 years, is the fact that we look at special aspects to make that determination as to whether a landowner would be would likely believe that injury would be caused. It's still
your position that the special aspects doctrine is consistent with the restatement, or does it depart from the restatement?
I believe it is consistent with the restatement.
Then how do we get ourselves in a situation where you're now asking us to reject the examples that the restatement gives of the principles that it embodies? How exactly do we get ourselves into this box?
So we get ourselves here because as Michigan courts have further defined the common law in Michigan, not just, and certainly the restatement is a large part of premises liability law in Michigan. It's not the entirety of it. And if we look over time what's been done, we've clarified and relied upon Michigan common law when addressing each of those comments that have been made. And if you look at, and it's in our brief, we've gone through line and verse citing case law that, and I see my time is up if I can finish.
Please.
Okay. Michigan law has gone through 4, I believe, of the 5 comments and found that Michigan common law does not actually stand for the proposition that the comments in the restatement do. This is just the last iteration of that comment, and the Michigan judiciary basically saying we don't agree with the commentary, but we agree with Michigan common law and as it's been developed over time. That's how we get the situation we are in now.
Can you give me an example of a situation when someone doesn't have an option of whether to confront an open and obvious hazard?
If we're talking about ingress, we're talking about things that a plaintiff can do to avoid having to go to a particular location. So that's one option that's available. In this case, the plaintiff has admitted that she went into and out of this restaurant 3 times, the front door, not the back door, but the front door 3 times. That's at page 46 and 49 of her deposition. I think this case provides you that opportunity.
Well, that wasn't the question I asked. The question is, can you give me an example, a hypothetical example of a situation in which a person does not have an option of whether to confront a hazard?
Oh, I apologize. I misheard your question. Where somebody doesn't have an option, that's provided actually in Lugo, where we're talking about egress from a building. So that would be, for example, leaving a shopping center and having a 30-foot deep pit filled with ravenous sharks. That would be the example there, where the danger has to be encountered in order to leave a particular place where there is no other option available.
So we need a situation where you somehow managed to find your way into the supermarket, but on the way out, the pit is filled with water and sharks, and therefore you have no other way out. That's what we were talking about, those, because that happens a lot, right? Those kinds of
I included the sharks based upon prior arguments that have been had in the
well, I get it.
But
I get it. The water, but I mean, so it's this whole special aspects doctrine, that part of it is only intended to get to situations which arise sort of out of the air after you've already entered somewhere, and then you can't leave. That's the only situation we were concerned about.
That is one of 2. The other is when the possibility of serious harm or death was so significant that even despite
that's not effectively unavoidable, though, right?
I agree with that, but that was the other instance that was discussed in Lugo.
All right. So your view is it's so narrow as to almost never come into play practically. That's how you would define that special aspect, effectively unavoidable.
I wouldn't classify my argument as saying that, because if you look at the case law over time, certainly the special aspects doctrine has been applied to situations where there are circumstances where a condition is effectively unavoidable. It's narrow.
Don't we look at whether someone has a choice of whether to confront the hazard? Isn't that the way those cases and the Court of Appeals cases have gone?
We look to see whether or not there are options available to the plaintiff to avoid the condition. That is correct. And there certainly have been situations where that's been discovered in the past.
And you think the fact of someone's employment shouldn't inform whether they have a choice of whether to confront a hazard or not? They should be willing, for example, to lose their job. I'm not talking about this case now, because you're asking us to adopt a clear, and you said objective and easy to apply rule for every case. So say that you're going to work to your job and there's a hazard in the way, and you know that if you don't show up, you're probably going to get fired. Do you have a choice of whether to confront that hazard or do you not?
I do have a choice.
Okay.
I
What
have,
would you do?
if the choice is binary, one or the other, yes. This case, as you indicated, I'm not saying it's binary, but if the situation is binary, the decision always is you can avoid not going to work. But there are other options that are available too. I have a cell phone. I can call and say, I can't get in. Is there something else that I can do? I can make other arrangements. There are other options that are available that don't encounter even leaving, for example, in this case, a motor vehicle to encounter an otherwise known condition. I'm not saying that to the exclusion of all others, you can leave the premises. I'm saying that there are reasonable alternatives that are available, especially in this case.
But so
But
it kind of gets to my earlier point. In your view, there are always options, which means the doctrine is so narrow that it's probably never likely to be practically relevant to any situation.
Based upon what I've said and what the Court of Appeals have said, I use the alternative of having a cell phone. But if a person doesn't have a cell phone, if a person doesn't have any other way of communicating to any other person in the world, and they have a binary choice in that binary world, then yes, it would be effectively unavoidable. It would be effectively unavoidable. That's not the case.
It's interesting because your initial discussion of the topic was that we don't want subjective rules, but in your discussion just now, you got very subjective in terms of what access the person has to what types of electronic devices and all these types of things. I think the restatement operates on a more general plane, doesn't it? Where the landlord would have an obligation to do something about a dangerous condition, even an open and obvious one, if they thought, it's right in front of the building and people were likely to try to get around it to get to work that day. That's sort of the obligation the restatement puts on the landlord. You would say that, no, we should assume what people have cell phones or they can work remotely from home or something else. That's a lot more subjective, right? We have to sort of go person by person to figure that out.
I disagree with that characterization. I believe the record in this case identifies that it's not a binary. There's only one option of not.
We're trying to figure out a rule to fashion to develop the law for the next 1,000 cases, right? This topic about employment does come up, has come up from time to time in the Lyman case and in some others that we've had, and we're trying to grapple with the issue of whether someone's employment would require or cause them, to whether a landlord should anticipate that someone's employment would cause them to confront even a known hazard, right? That's the general question, or whether that should not be a consideration at all. We've said in other cases that, for example, going to the gym isn't as sufficient. Having a contractual right to go to the gym isn't sufficient. The question in this case, of course, is whether going to work out is different than going to work, or is work in our state, considered the same level of importance as working out. Your livelihood, what puts food on your table, supports your family, and so forth. Or would somebody be more likely to confront a hazard, should the landlord anticipate they would be anyways, for their job than they would to go to the gym?
And if I may respond, the problem with looking at it in that way is it doesn't look at the condition, which we've always been known to do in Michigan. That's what the common law requires us to do. And once you get...
You confuse me when you say that, because now you're saying that we in Michigan has departed from the restatement because we only look at the condition and we don't look at what the restatement says, whether the possessor should anticipate the harm despite such knowledge or obviousness. You just want us to look at the obviousness of the condition, which is fine, but that's not what the restatement says.
And as I said earlier, Michigan common law is based in part on the restatement, but it also has moorings in other cases as well. So I don't think we blindly in Michigan accept the restatement. We accept it on a case-by-case basis. Bertrand and Riddle did, and they applied it in the way that Lugo clarified. And all I'm asking the court to do in this particular case is to clarify once again that it's an objective standard based upon what Lugo identified as the narrow special aspect.
Thank you, counsel.
Thank you.
Mr. Barata.
Thank you, Chief Justice McCormack. May it please the court, Chris Barata on behalf of the plaintiff appellee. Your Honors, this is my first time in nearly 26 years of practice appearing before this court. I'm honored and humbled to be here today. Thank you for your time. I would like to reserve 2 minutes for the free fire zone. We would ask that this court deny leave to appeal and let the Court of Appeals decision stand. The plaintiff's employment is in fact a relevant consideration in determining whether or not a condition is effectively unavoidable. As Judge Shapiro correctly stated in his concurrence in the Court of Appeals below in this case, any worker who has to forego employment in order to avoid a condition he is required to confront is inconsistent with substantive justice. This is the principle of the plaintiff appellee's argument today. Your Honors, we don't have to overrule Hofner in order to stay within the framework and determine that employment is in fact a relevant consideration. Hofner involved a woman trying to access premises. She had a contractual right to use the premises. Specifically, she was going to exercise at a health club. The court in Hofner indicated that that contractual right to enter upon the premises was no greater than someone's employment right to enter upon the premises. We would argue that that was dicta, as the plaintiff in Hofner employment was not involved, and it's not binding precedent. However, more importantly, employment doesn't alter the standard. Considering employment doesn't alter the standard in a premises liability case, and considering employment can be done in an objective fashion. There are a couple things when we look at a premises case that we need to consider. The first, under Stitt versus Holland, is what is the status of the plaintiff upon the premises? In order to address that and determine the status, a subjective inquiry is necessary. That is, why is the plaintiff here? That particular plaintiff. Is he or she here for recreation, for work, for friendship, or simply a trespasser, whether known or unknown? That subjective standard, the intent of the plaintiff, is then applied against an objective view of the premises, which has always been the law in Michigan, and we're not asking this court to adopt a different standard. We believe the condition of the premises in determining whether or not a hazard is effectively unavoidable, whether there's an unreasonable risk of harm, whether the condition is in fact open and obvious. Those are all objective factors that don't need to be disturbed in order for the court to look at employment as a relevant consideration. Some examples of questions concerning employment that can be framed in an objective way, which won't necessarily add to litigation, it'll just require a more detailed analysis during discovery, are what was plaintiff's purpose on the land for her employment? Did the plaintiff's employer require her to park or enter on the land in a certain area? Did the defendant require the plaintiff to be exposed to or encounter the open and obvious condition in order to be compensated? Those are all objective framework questions wherein each particular plaintiff's circumstance is not going to create a separate category, as defendant suggests. The duties of an invitee are well settled and set forth. We've had that since Quinn Levin, and perhaps before. Was the defendant's conduct reasonable under the circumstances? The plaintiff is judged under the same standard. We have examples in the Court of Appeals of two different situations involving employment, Bullard versus Annapolis Hospital and Lyman versus Friedland. Lyman versus Friedland, the Court of Appeals simply, this is one example of how the court could analyze employment, how it made it work in an objective framework. The court made the determination that the hazard was in fact effectively unavoidable due to the health, safety, and welfare of the premises possessor and the plaintiff's need, albeit subjective, to enter upon the premises and encounter the hazard. In Bullard, the plaintiff, which is distinguishable on the facts here, the plaintiff didn't actually have to go and fix the generator. The plaintiff didn't have to go at that particular time. The conditions were icy and frosty. The plaintiff chose to voluntarily encounter the hazard. On the other side, Your Honors, we have Riddle and Bertrand, which followed the restatement. In particular, Section 343A, which, as Justice Viviano indicated just a few minutes ago, the standard there is that a premises possessor has a duty to protect its invitees against those dangers if the invitor should anticipate the harm despite such knowledge or obviousness. Lugo doesn't incorporate this standard. Lugo harkens back to the days of contributory negligence, which was abrogated or rejected in Playcheck versus Sterling Heights in 1979. Lugo.
Mr. Brett, let me interrupt you because to make sure my colleagues have time to ask you questions if they have them. So, and I want to Justice Bernstein, I skipped you last time and I apologize. We will go back to you, and Mr. Conn, you might have to come back if Justice Bernstein has questions for you. That was not intentional. I just lost track of time. We are starting with Justice Clement.
No questions. Thank you.
Justice Kavanaugh.
I don't have any questions.
Justice Markman.
Yes, I've got a question. Counsel, I think that Mr. Conn was exactly right to focus upon the question of predictability. When you're talking about the common law and its implications, you're talking about countless ordinary and pedestrian interactions that occur every day around the state of Michigan that define almost every personal interaction that one individual has with another individual. And every property owner in this state is obligated to structure their property affairs and to maintain their property affairs in a way that is defined by common law standards. The predictability that Mr. Conn seems to see here is furthered in his judgment, and I think correctly, by a sense that the property owner only needs to assess the open and obvious potential harms of an open and obvious risk by a single objective standard, rather than upon a potentially limitless number of standards defined by the individual circumstances and inclinations of every Michigan citizen. So in the next 1,000 cases, it seems to me, counsel, the question is whether we're going to have a single standard defining the nature of interactions between the property owner and the public, or whether we're going to have 1,000 almost impossible to anticipate standards. Today, all you need to look at is whether an individual is an invitee, a licensee, or trespasser. You don't need to take into consideration the work exigencies of that person, the personal lifestyle priorities that he or she might have, the sense of risk aversion he may bring to his daily interactions, and 1,000 other personal instincts and inclinations. Aren't you creating a much more unpredictable environment, in a legal environment in which predictability is the single most important defining facet of what ought to be the legal order?
Justice Markman, your question is interesting, but it's not going to create any ambiguity or additional duties or difficulties in ascertaining whether or not exceptions will be allowed or disallowed. Again, viewing employment is an objective consideration as to whether or not the plaintiff was compelled to enter upon the property. Hoffner indicates that that compulsion must be weighed under the circumstances. So when Hoffner says, when the Supreme Court says under the circumstances, it necessarily implies that we need to consider both the plaintiff's subjective reasons for being compelled to enter the property against the defendant's duty. If, as Judge Tuchel indicated in his dissent, and as you seem to be indicating, the plaintiff could simply not show up for work or not enter upon the premises, then the defendant will never have a duty, will never have a reason to anticipate harm despite the invitee's knowledge, and the plaintiff's actions will be barred without consideration as to why they would enter on the premises. This, to me, is inconsistent with substantive justice. I believe the court wants to promote the interests of commerce, health, safety, and welfare of all of its residences. If the plaintiff's reasons for being on the property are never considered, then there's never any box which can fit inside the effectively unavoidable exception. Thereby, landlords will never have a duty to maintain their property. This is something.
Landlords have a duty to maintain their property safely, but they also have the right to look at an open and obvious risk upon their property and assume that people are going to conduct themselves with some sense of personal responsibility and individual accountability. So, I mean, there's a significant obligation placed on the landlord, but it's one that they're entitled to be made aware of. It's one they're entitled to be apprised of before an occurrence takes place. They're entitled to know what the standards are by which they can maintain their property should it be encountered by any one of 10 million people in the state of Michigan.
I respectfully disagree, Your Honor. Lugo doesn't provide any particular duty on behalf of an invitor except to let a hazard such as snow or ice become so prevalent on the property that it is an open and obvious condition. If no one needs to enter upon that property, then there's never any need to remediate or duty to maintain the premises. I believe that the better approach is the restatement approach, and the legal questions then become, should the invitor have remediated the danger despite its obviousness, and whether the invitee failed to use reasonable care. This is a much more balanced approach, evaluating the conduct of both parties consistent with our principles of comparative negligence. Lugo is an abrogation of that, and it does not follow the restatements. The plaintiff in this case, Justice Markman, couldn't simply elect not to go on the premises. That's not consistent with her understanding, her responsibility of showing up to work. Concurrently, as I just indicated, if Sage should never have anticipated harm despite the invitee's knowledge, then there's no duty to maintain, no duty to warn, and premises liability in Michigan will simply cease to exist. Lugo only provided for one illustration of the effectively unavoidable exception, and that was during egress, where someone is trapped in a building and has to encounter the hazard. There's no example set forth in Lugo for ingress. So those coming upon a property, whether in this case they're employees of the restaurant, owners of the restaurant, or customers of the restaurant, it's the same. The Lugo analysis, in my mind, Justice Markman, is not the correct analysis.
Thank you, counsel. Thank you.
Justice
Thank you.
Mazzara?
No questions.
Justice Viviano?
No questions. Thank you, Mr. Barada.
Thank you, Justice.
Justice Bernstein?
No questions.
Do you have any final comments, Mr. Barada? You have 1 minute and 7 seconds. 6, 5, 4.
I don't have any comments. Thank you, Chief Justice.
No, thank you very much for your argument. Mr. Conn, give me another second to check with Justice Bernstein. Justice Bernstein, do you have any follow-up? Again, I apologize.
No questions.
Okay. Well, thank you both. The case will be submitted.